Hello everyone and welcome to another of our coffee break short webinars. In these webinars we are bringing industry experts in to chat to us about different risk aspects that have arisen during the pandemic and also are central to our practices. Today we're looking at the private client sector and I'm joined by Ben Furlong from Estate Search. We will have a chat today around liabilities and the risks for practitioners of not necessarily establishing all of the liabilities. During the pandemic, we've obviously seen a considerable change in practical realities of our day-to-day business. And we've also now got the anticipated release of the 9th edition of the Probate Practitioners Handbook, which is going to give us a considerable number of changes that we need to take account of. So we've already seen changes in terms of the changes to the Wills Act, where we are now able to electronically sign documentation. We also very specifically today are going to just talk about the liability aspect on estates and whether or not it is possible still to rely on Section 27 of the Trustees Act, and whether, from a practitioner point of view, simply advertising, as we previously thought, in the Gazette is sufficient to protect both the estate, and then what do you do as far as the beneficiaries are concerned, where they are not protected by those steps that you're taking. Ben, would you just quickly like to introduce yourself, and then we'll just have a couple of questions for you.
Yeah, of course. Thanks, Paul. So yeah, my name's Ben Furlong, as you said. I'm the Client Services Director at Estate Search and one of founding members. We've been going for about 3 years now, and our background has been in legal technology. All of us involved for the past 10 years or so. Initially, we were involved in the conveyancing sector, as many people are, and I think that's an area that obviously is heavily invested in terms of legal technology. But a few years ago, we moved into the private client space just because we saw there was an opportunity there to start building useful technology that could really help try and update the process, improve the process, and just make it easier for practitioners in that space.
Thanks, Ben. So, just from a general perspective, would you agree it's becoming harder for practitioners to identify estate accounts?
Yeah, definitely. I think I would. Certainly in our experience dealing with the estates and the clients we work with, we see difficulties. We see an increasing number of inquiries from clients looking for help, especially during lockdown with issues accessing properties. But I think more generally, to point outside of our own experiences, there was an interesting survey that was done by Direct Line last year, where they surveyed about 3,000 practitioners. And the headline outcome from that was that 88% of the people they spoke to believed it was getting more difficult to identify estate accounts. So it's not just our experience, it's the wider experience, I think, of the industry. There's a few reasons for that. I mean, traditional due diligence tends to be going through the paper bags or the person's property, which can be time consuming if there's a lot of paper and the person was a hoarder. But what's happening is with the shift in our society, people are starting to manage their lives and their finances online. So we're seeing obviously accounts move online. We're seeing people shift to paperless billing. So those traditional methods of going through the paper that was there are becoming more difficult. I think added to that is the sheer number of financial service providers that are out there now. Over the past several years, the number of providers that provide a range of accounts and services, the number of people that provide credit cards and current accounts is growing. And on top of that, nowadays we're actively encouraged to switch. We are informed and educated to go and look for the better deals. So we change accounts regularly. So we've got holdings in lots of different places. That adds to a chaos or a mess of what accounts are like during our life, and trying to make sure that we're planned for that and they're ready for that at the end of life can be difficult. Another thing that seems to add to this is just a lack of planning. Some people are pretty good, but a lot of us, live our lives a bit messily, and we're not always necessarily ready for that end of life point, having everything tidy, or having had conversations with our loved ones about where all of our accounts are.
Yeah, no, it's increasingly difficult, not just within the private client area, but across legal practices. And obviously from our perspective, we see and look at it from a risk profiling perspective, and the necessary changes to firms in relation to their risk assessment on the outset of the files, and the way that they are viewing those online transactions, those transactions that are not as easy to find as perhaps it was historically, as you say, going through the paper bag with the bank account results. So from your point of view, what are the risks for practitioners at the moment?
I always find it useful to come back to sort of what the role of a practitioner is, and what the role of PR is during this process, which ultimately in the legislation sets out that, you know, the duty is to collect all the assets, discharge all the debts, and then distribute the estate in accordance with law. And those two things, collect the assets and distribute the debts, the sort of the core jobs of what, you know, one of the core jobs of what you're trying to do. There's a lot that goes with it, but that's the underlying job you're trying to achieve. And similarly, a professional advising a lay executor is under a duty to advise the PR they're advising what those risks are and how to carry that job out, and what the issues can be in achieving that goal. I think in terms of the two things that we look at, assets and liabilities, the risk with assets, I mean, while on the face of it, missing an asset isn't really a problem because you find it later and then it's more money for the estate. But finding an asset after distribution creates cost. So you've got to speak to the bank, you've got to send letters to get the money back in. You might have to recomplete IHT forms. It might make the estate taxable. You might have to get a reseal of the grant, and certainly you're going to have to contact and speak to the beneficiaries, recheck them, make sure they're okay. So that's all cost. And again, if you've got an asset of, you know, which is 6 figures, perhaps not such of an issue. But what we tend to commonly see is you might discover an asset of sort of a few £1,000s, maybe tens of £1,000s, and cost eats into that quite significantly. And beneficiaries aren't always keen or happy about having to pay more cost later on when they think it should have been found earlier on. Also, what's interesting from an assets point of view, a recent conversation we had with Leslie King, and I know you pointed to the Probate Practitioners Handbook update at the outset, but we were having a conversation with her about the changes and, you know, what's happening with that book that's coming out, and she mentioned that HMRC themselves are sort of not taking too kind of view on people who aren't doing all reasonable due diligence in terms of finding assets. And what reasonable means, it is perhaps up for debate. There's no set definition. So anything that people can do to satisfy that or show those steps through, I think is helpful. Conversely, the other side obviously is liabilities, discharging liabilities, and that's potentially I personally see more risk in that, you know, missing a liability creates personal liability for the executor, which is an issue they want to avoid. And again, traditionally, what PR would do, or whether they're a professional or whether they're being advised, is take out a trustee notice to protect themselves. But I think the problem with that is, as you look into that, and again, think about the society we're in now with the sort of digitally connected age, Section 27 makes it quite clear under subsection 2B, if you're inclined to go and read it as we have been, that it doesn't free the executors from doing any reasonable or advisable searches. And there's those classic words again. And what is that? And again, you know, with the change in how things are available, what you can do now is you can electronically check credit reference agency data, so you can see what credit cards and mailing orders and utility bills and accounts someone had. And that's quite, it's quite cost efficient. So is that reasonable? And if you do a notice without doing those kinds of checks, are you still covered? That question is, I think, there to be answered in time. So it's something to be aware of, and it presents a risk. I mean, the other more general problem with placing notices to protect yourself is that it doesn't stop the liability following into the hands of the beneficiary. And as we know, if a beneficiary gets a knock on the door saying that they owe some money from an estate they've already inherited on, they're not really going to be very happy about it. So there's a risk there that then the beneficiary comes back to the professional who's advising them when they're an executor, or was a professional executor, and sort of says, well, hang on a second, why have I now got this liability? I'm not happy about this. And then, what action they might take.
I think that's interesting, because that sort of leads us into one of the other points that I was thinking around, and one of the things we're seeing is that there is a substantial increase across practices in the number of complaints just at this moment. Clearly, we've got quite a glut around conveyancing, and historically, private client has been a little bit immune, probably, to the volume of complaints that exist in the marketplace. But actually, customers are much more informed now, and clients are far more likely to express their dissatisfaction. And we've seen quite a lot of increase in complaints around this area. Challenges, from insurers around how much due diligence is being conducted, and also the fact that, particularly in the private client area, things can come back at a much slower rate, and actually your complaint may well be quite a long way down the road, and the damage that that can do to your reputation and to your profile as a business. Are you seeing similar things with the firms that you're working with?
Yeah, I think we're definitely seeing an increased number of inquiries in how people can help satisfy that due diligence to show that they've done all the reasonable steps. And that's often being driven by beneficiaries who are sort of asking, what steps are you taking? Are you contacting these financial institutions? Can I be sure you found everything? And that's being driven by the consumer, because they're becoming more aware of the issues and more concerned about protecting their inheritance. I think alongside that, the other issues that we tend to see, or that certainly I'm aware of commonly happening in the wills and probate space, are issues around delays. People get frustrated with how long the process takes and the information not being transparent. So again, anything that people can do to help give their clients access to better information, show them what's going on through the process, I think helps improve that communication and protects against future claims, inquiries or complaints, which is a sensible thing to be thinking about. And like you say, in terms of, real, there's an issue or arguably a negligence complaint, the issue here and in this whole sector is it's a long tail. So once you've done the work and administer the estate, it's potentially a year, 2 years, a few years before an issue crops up. And, what have you got in place at that point, several years later, to be able to see what you did on the file, what steps you took, that then you can present to the client to protect yourself against such a claim. So I think that's becoming an issue, and the more that people can do now to build those processes in place to make sure they can protect and defend against those claims, the better.
Yeah.
And certainly I'm sure PI insurers are looking at those kinds of processes and things as well, similar as they are in conveyancing.
Yeah, and I think what we like to do with these short webinars is just try and give something from a practical point of view for practitioners to actually take away, and in a relatively straightforward way, how to change processes and procedures actually to protect themselves. So if you've got any advice or any recommendations for firms on how, in a real practical environment, they can actually cover off some of these risks that we're highlighting.
Yeah, I mean, practical steps is my favorite part. So actually, theory is great, but what can we do about it? There's a growing number of sort of services that can help identify estate accounts, both in estate administration matters and court protection matters is another area that's becoming increasingly of interest. Some of these tools are free online tools, which can be helpful and people can access and use. My advice is always just to understand how those tools work and be aware of the limitations, because they can be helpful, but they might have limitations. But similarly, there are commercial searches such as the Estate Search Financial Profile Service, which offers a comprehensive method that you can demonstrate the due diligence and all the reasonable steps you've taken to help try and find and identify all those estate accounts to hopefully add value for your client and also protect yourself going forward. I think ultimately what practitioners need to do is just review their policies and procedures and make sure they're doing that in light of emerging risks, emerging tools, and what the sort of developing best practice is. So certainly what we recommend or advise is that practitioners take a look at their client engagement letters, make sure they're talking about what the potential issue is around missing assets or missing liabilities, what the potential implication is, and just advising that there are solutions or options that can help the client with that, and take their instruction on whether the client wants them to or not. I mean, that's really good as a minimum. And we've got some resources that we can share and can be included alongside this sort of chat that people can use freely, just to include and review against that. I mean, what we're tending to see, or more commonly seeing certainly, is that firms are adopting a policy where if they are the executor, they'll take quite a hard line and be like, this is what we are doing, this is our process, we will do some kind of search or process. And if they're advising a client, they just make sure that it's very clearly worded in their client engagement letter about what the issues are, what the possible solutions are, and they document and take the client's instruction to protect themselves.
Thanks, Ben. I think that's really helpful. I think we're all faced with a very, very quickly changing marketplace at the moment, and the pandemic has been helpful in lots of ways. It's brought forward things that we've been talking about doing for many years, but also it's exposed practices to some quite new risks. And that review of process and policy, I think I absolutely support that. So thank you very much indeed for your time. Really appreciate it. And for those of you that are watching, please look out for the next in the coffee break sessions. We have got another one coming up shortly in relation to cybercrime and identity theft. So thank you very much indeed for your time. Thanks, Ben.
Thanks, Paul.